The retrial of those accused of killing Nathaniel Julies started in the Palm Ridge Magistrates Court yesterday while the state's first witness was taking the stand. The trial is being heard for a second time before a new judge after presiding judge Ramarumo Monama died earlier this year. Let's get some legal insight now on the consequences of the retrial. I'm joined by Ian Levitt, Director and Partner at Ian Levitt Attorneys. A very good afternoon to you. Thank you so much for your time. A retrial in a very complex matter, of course, involving police officers. The process in itself, perhaps let's get clarity on what the implications are of a retrial and how it will be carried out.
So a retrial really is a trial that starts afresh. It's as simple as that, as devastating as the consequences are and as far-reaching as they are. It's really a trial that starts again, but with a certain nuance, and that is that the evidence that has already been given doesn't just disappear. So you can, either side could use that evidence to cross-examine other witnesses or the witnesses who testified for issues of, for example, credibility that they would want to cross-examine on. But essentially, it's a trial that starts right from the beginning.
So what are the far-reaching implications that you hint at as you were answering the question?
The far-reaching consequences are as follows. First of all, accused have the constitutional right to a fair trial, which includes a speedy trial. And society and the community as a whole, including everyone that's been affected by this case, has, I would say, a right to seek justice and for justice to prevail. Now, if it is that for example, a witness has passed away that has already testified, or any of the like, for example, similar evidence cannot be obtained, then the trial is not going to have the same credibility that one would have otherwise have had if it had run in the first place.
So the court in this instance has already heard from 23 witnesses before the judge passed on. What does it mean for those witnesses and their testimony? I mean, you make mention of credibility being one aspect, but in the greater scheme of the entire matter, also considering the psychological impact and the evidence that they're giving before the court.
That's exactly the point. And you know, a pre-trial is about to be convened in this matter. Hopefully the state and the defense will come to as much senses as they can to try and limit the issues, which is the very real purpose of a pre-trial conference. The defense must do so in order that they cannot complain about the length of a trial that it takes, and the state needs to also curtail the issues that need to be addressed because they also do not want to be accused of prolonging the trial. The problem that you do have is that I have seen newspaper reports or news reports that the state and the defense have tentatively agreed that the evidence can, or the transcripts of the evidence can just be given to the previous witnesses and merely ask of them if they confirm that the evidence that they previously gave is their evidence. Now, the problem with that is I would think that on appeal that wouldn't pass muster because the very fact that trials take place with witnesses in the witness box under cross-examination is that a judge makes a finding on credibility if they believe that witness or not. That is why trials are not, that's exactly the reason why trials are not done on affidavits or on statements. They are done by witnesses giving evidence and the judge to adduce the credibility of that evidence.
So should that be the case and should it play out that way in court, what does it mean for the outcome of this matter?
Well, my fear is that if, the state and the defense can theoretically agree anything, but it would be up to the judge to determine if their agreement is lawful. It wouldn't serve a purpose for the state and the defense to just simply agree on something which is convenient to them. And I would expect that the Deputy Judge President has appointed a senior judge, and he would be able to make rulings which would, at the end of the day, pass muster when this goes on appeal. We do know that in murder trials, most murder trials, if there is a conviction, that they go on appeal, and that's why every single loophole or every single door has to be closed in order that there's not a technical deficiency that the trial would have taken place that the accused may be acquitted on.
So what would then happen in an instance where perhaps one or two or however many of the 23 witnesses who have already given their evidence now say that they cannot attend this matter? What would that evidence be brought forward and still considered or completely ignored because that the witness was not able to come to court again?
And that is exactly what I alluded to when I said the far-reaching consequences. You would possibly have witnesses who are unable to, for whatever reason, come to court. Now, the evidence that they gave in their initial trial has to be disregarded because it's not evidence. It's in effect sort of hearsay. It's really a document indicating what somebody previously said. That is not evidence. You know, documents are handed into court every day, but you've got to question what is said on the documents, whether that is true or not. And if the witness does not come to court and testify to what he has previously said, you're going to have a problem with this case.
Very well. Thank you so much for that legal insight. Ian Levitt, Director and Partner at Ian Levitt Attorney, speaking ahead of the Nathaniel Julies retrial.